Hello to all my dear CA Foundation students. Today, what we are going to discuss is we are going to discuss the September 24 question paper. So, we'll do it a little quickly and just get the whole glimpse of it and what provisions we are supposed to write in each of the questions. So, let's just go into the question paper. Mr. L let out his residential house to Mr. M for 50,000 per month for a period of 1 year. According to the rent agreement, electricity bill will be paid by Mr. L, but Mr. Who will pay the electricity bill? Mr. L. But Mr. L could not pay the electricity bill up to 5 months due to his financial hardships. The electricity board sent the notice of disconnection if it is not paid within a week's time. Notice of disconnection if it is not paid within a week's time. To avoid all this, Mr. M paid the electricity bill of 50,000. Who was supposed to pay? L. Who paid? M. Later on, L refused to reimburse 50,000 and argued that he had paid bill voluntarily because of his own interest. So he says, I will not repay you the money because you paid it on your own at your own wish. So I'm not liable to repay. When a person makes the payment on behalf of another to protect his interest, then he has a right to get back whatever he has paid. So on that ground, and this is what? Quasi contract. Quasi contract payment made for another person. Can he recover the money? Yes. Mr. A offered to sell 25 chairs to Mr. B at 1500 per chair on 12/2/24. A promised that B that he would keep the offer open till 15/2. However, on 13/2 he sold those chairs. Now the offer was a standing offer. The offer was a standing offer. But before the period of offer was over, he made the same offer to someone else. He sold those chairs to Mr. C without the knowledge of B. In case of standing offer, if within that same time, if you make the offer to someone else, it's an automatic revocation of the offer. So, can we say the offer to B is revoked? Yes. And he sold the chairs to Mr. C. Is the sale valid? Yes. Mr. B communicated the acceptance of the above offer. Is it a valid acceptance? No. Why? Because the offer has been revoked. So, can Mr. B claim damages from A? No. Mr. A was running an orphanage. His friend Mr. S, a philanthropist, agreed to donate 2 lakh for treatment of a child who was suffering from cancer. On emergency, Mr. A incurred 1.5 lakh on the treatment of a child. He agreed to donate. This is what? Donation. Donation comes where? No consideration, no contract. A promise to give donation, is it enforceable? No. On emergency, Mr. A incurred 1.5 lakh on the treatment of a child. Now Mr. S refused to pay. Whether Mr. A can claim 1.5 lakh from S with reference to the provision. When a person makes a promise to give donation, it's not enforceable. But on the basis of the promise, if the other person has incurred any liability, can he recover? Yes, he can recover to the extent of liability incurred. So he's liable to pay 1.5 lakh. Kamala CA started his e-commerce business by incorporating an OPC on 1st October. He, being a sole member of the OPC, named his brother Sudhakar with his consent as his nominee in the MOA of the OPC. Now, Kamal intends to replace Sudhakar and to nominate any one of the following shortlisted friends as nominee with effect from 1st Jan 24. Robert, an Indian citizen and a resident in India, shifted his residence to the USA on the 31st of May 2022 and has not returned to India till 1st Jan 24. So here he is with effect from 1st Jan 24. That means we are nominating him as a nominee for 23-24. And for 23, first of all, he should be a natural person. He should be an Indian citizen and whether resident in India or otherwise. But ICI has said very specifically and stayed in India for 120 days in the immediately preceding financial year. 23-24, he is going to be appointed. So I have to see his residential status for 22-23. He left India residence to US on the 31st of May 22 and has not returned till 1st Jan 24. That means in the year 22-23, he had stayed for 30 days in April, 31 days in May, which is 61 days, which is not 120 days. So can he be appointed? No. Dinkar, an Indian citizen and non-resident in India, came for employment in India on 1st April and have been continuously staying in India since then. Now he's an Indian citizen, but again he's an he's a non-resident Indian and he came to India first time on April 1st, 23. But I need to see the residential status for 22-23. In 22-23, he was not in India. So is he eligible to be appointed? No. XYZ Limited was incorporated to hold the patent for a new product. The company is expecting to start its commercial production within the next 2 years. In the meanwhile, for timely installation, the company has placed the purchase order for plant and machinery with a down payment of 1 crore. Referring to the provisions of the Companies Act, examine whether the company can go for acquiring the set. A dormant company means a company which has been incorporated for a future project or to hold any assets, including any intellectual property, and does not have any significant accounting transaction. Here, the company was formed to hold a patent, and this company had purchased a machinery for timely installation and has made a payment of 1 crore. Now, this payment of 1 crore, it is a significant accounting transaction because only those four transactions are not significant: payment of fees to the registrar, payment to fulfill the requirement of this act or any other act, allotment of shares to fulfill the requirement of this act, and the last one was any expense for maintenance of office and records. And this purchase of plant and machinery does not fall under any of the four. So this is a significant accounting transaction, and in case of a significant accounting transaction, you are not a dormant company. Direct questions, I'm not going into that. Messrs. RK Traders made a contract with Messrs. CK Traders for purchase of 2000 kgs of basmati rice specifically grown in Chhattisgarh state, should be packed in pink color bags of 25 kgs each to identify the place of origin. Can we say this is description? Now, as such, the Act does not define the term description, but description can be place of origin, packing, quality, anything can be a description of the goods, right? Here we have said that we pack it in this color bags so that we can identify it belongs to this place. The seller agreed for specific packing of rice grown in Chhattisgarh state. By packing by misunderstanding, staff of the seller packed the quantity of 1800 kgs of basmati rice grown in the state of Maharashtra in white color bags of 30 kgs each, and the remaining quantity of 200 kg grown in Chhattisgarh state in pink color bags of 25 each. Referring to the provisions of the Sale of Goods Act, whether the buyer has a right to reject? Yes. When the sale is made by description, the bulk must correspond to the description. If the bulk does not correspond to the description, the buyer can return the goods back. On the other hand, what is the remedy available to the buyer if he has to accept the entire quantity to fulfill the other contracts with other parties? If he cancels, he can claim the damages. But if he accepts, he cannot claim anything. He will get the goods, he is liable to pay, but he cannot claim anything from anyone. Karthik agreed to sell his laptop to Vasant for a price to be fixed by Kusum. So, price is to be fixed by a third party. Price is to be fixed by a third party, right? However, before the delivery of the laptop, Karthik changed his mind and did not share any particulars and configuration of the laptop with Kusum, which made her unable to do the valuation. Kusum refused. When the price is to be fixed by a third party and the third party refuses to fix the price, the contract is what? Void. But But here, if you see, Karthik changed and did not share any particulars and configurations of the laptop with Kusum, which made her unable to do the valuation. He refused on her own or because she was forced by the parties to the contract. Forced. So any party, if any party prevents the third party from fixing the price, the defaulting party has to give damages. That means what? Here it was because of Karthik that the price was not fixed. So Karthik is liable to give damages to Vasant. Vasant needed laptop for his project, so he promised Karthik that if the laptop is delivered to him, he would pay a reasonable price for it. However, Karthik decided not to sell his laptop to Vasant. Now, Vasant wants to know from you, being a legal expert, whether Karthik is bound by the promise. No. If he does not agree to deliver, what is the other remedy? He can claim the damages. I told you, direct questions. I don't want to waste my time. Ram and Shyam are partners in a partnership firm styled as RS and Company. Gopal, a renowned businessman, is their common friend. Ram introduced Gopal to Sundar, a supplier to the firm as his newly joined partner. Gopal, knowing that he's not a partner, preferred to keep quiet. This is partner by estoppel. This information about Gopal being a partner of the firm was shared by Sundar with another businessman, Madhav. Next day, Sundar supplied raw material. So, when Sundar supplied raw material on credit, firm is liable. Is Gopal also liable? Yes. And Madhav lent 5 lakh to the firm. So Madhav lent on the understanding that Gopal is a partner. So Madhav lent rupees 5 lakh to the firm. Is the firm liable? Yes. Is Gopal liable? No. Because a partner is liable only to the person to whom such representation was made and not to any other person. Advise Gopal whether he is liable to Sundar? Yes. Whether he is liable to Madhav? No. On admission as a new partner, Amar agreed to be liable for the existing debts of the firm by an agreement signed by all the partners, including Amar. He agreed to be liable for the existing debts. Even if a partner agrees to be liable for an existing debt, he is not liable to the creditor. Examine whether Amar will be liable in a suit filed by the creditor against the firm. No, because he is liable only to the other partners, not to the third party. Suman having 10%, so when a partner agrees to be liable from a prior date, the third party has no right to sue him. Suman having 10% share in the property of 200 lakh of a firm retires. 10% share in 200 lakh, that means 20 lakh. Retires from the firm on 31st March. The firm continues with the business thereafter without final settlement of accounts between the existing and retired partner and earned a profit of 10 lakh during the financial year ending 31st March. Suman, in her own interest and in the absence of any provisions in the deed, claimed 3 lakh from the firm towards the use of her. They did not settle her accounts. So when they don't settle her accounts, she has a right to get her subsequent share of profit, which is 1 lakh, 10% of 10 lakh. And she has a right to, or she has a right to claim 6% interest on her share. That is 6% of 20 lakh, which is 1 lakh 20,000. 1 lakh 20,000. Right? She can claim this much. Whichever is higher, she can claim that. She claimed 3 lakh rupees. Can she claim? Is her claim valid? No. So there is no contract. Examine the validity. Not valid. She can only claim 1 lakh rupees or 1 lakh 20,000. JV Limited borrowed a secured loan of 5 crore from Star Bank Limited to meet its working capital requirement. However, the borrowing powers of the company under its MOA were restricted to 1 crore. The bank, so 1 crore. So 5 crore was asked. So 1 crore can they recover? Yes. And 4 crore is what? Ultra wires. On the due date for repayment, the company refused to accept the liability of 5 crores on the ground that the borrowing was ultra wires. The company's books of accounts show that the company has utilized the amount of 3 crores for repayment of its lawful debt. When the company has taken an ultra wires loan and the company uses that money to repay any, what do you say, to repay any lawful debt, in that case, that amount is, for that amount, the creditor steps into the shoes of the lender steps into the shoes of the what? Creditor, and he can recover that money. So they can, this 3 crores can be recovered. So this 1 crore, which is intra wires, can be recovered, and out of this 4 crores, this 3 crores can be recovered. So for the recovery of the loan, they can recover 1 crore and they can recover the 3 crores. After incorporation of Goodwill Private Limited on 15th May, the share certificate was issued to Amit and Sumit and Sumati, issued to Amit, Sumit and Sumati being subscribers to the MOA of the company without affixing the common seal. And under the signatures of Amit and Sumit, the directors of the company. The company has yet to appoint a CS. They have not appointed a CS. On objection raised by Sumati, a director, about the validity of the certificate signed by other two directors, Amit and Sumit clarified that since the company has opted not to have a common seal for the company, the share certificate signed by two directors are valid. Is it valid? Yes. If the company has a share certificate, if the company has a common seal, the share certificate must have the common seal. But if the company does not have a common seal, the share certificate shall be signed by two directors. And if the company has appointed a CS, by a CS, it has to be signed by the CS. Here they have not appointed. So it was signed by two directors. Is it valid? Yes, absolutely. Yes, it is valid. Referring to the provision, okay. Examine the correctness of the objection raised by one of the directors. So, objection of Sumati is not correct, and objection of Amit and Sumit is correct because they are right. What would be your answer if the company had a company? Then the certificate is not valid, because if the company has a company secretary, it should be signed by the company secretary. You done with this? Raghav found gold and diamond studded wristwatch value approximately 1 lakh on the roadside. He picked it up and then advertised in the newspaper that the true owner thereof can take the watch after showing proper evidence. After waiting for a certain period of time, when the true owner did not turn up, he gifted the wristwatch. So, first of all, there is a contract, quasi contract, or a contract of bailment, finder and owner. Gifted that rich wristwatch to his son Mahesh. Can you actually do that? No. A few days later, Madhav, the true owner of the watch, somehow noticed his watch on wrist of Mahesh. He approached him to collect the same, but Mahesh refused. In the evening, Raghav called Madhav and told him that he has incurred 20,000 to find the true owner, and if he fails to reimburse him the lawful expenses incurred, he will sue him for the recovery of that. Can he sue him? No. Can he retain the watch for that recovery? Yes, but can he sue him? No. Or retain the possession of the watch. Even he can sell the watch for recovery of expenses. Can he sell the watch? Yes, in some cases. So let's see the question. Gifting the wristwatch not valid because the owner, the finder has a right to possession, but no one other than the finder has a right to the possession of the goods. Warning Madhav to sue for recovery of not valid. He can keep the wristwatch, but he cannot sue for the for the expenses. Retaining the possession of the wristwatch till recovery of lawful expenses. Yes, because unless I get my expenses, I can exercise a lien over the watch. Selling of wristwatch for recovery of expenses. You can sell the wristwatch provided the value of the goods is two-thirds or more of the value of expenses is two-thirds or more of the value of the goods. The value of the watch is 1 lakh. The money spent is 20,000. It is not two-thirds or more of the value of the goods. So, can you sell the goods for the recovery of expenses? Not valid, as expenses is less. As expenses is not two-third or more of value. All right. Woolen Garments Limited entered into a contract with a group of women in July 23 to supply various woolen clothes for men, women, and kids, like sweaters, whatever. Before the commencement of winter season, can we say time is of essence here? Yeah. The agreement expressly provided that the woolen clothes shall be supplied by the end of October, time of essence, before the starting of the winter season. However, due to prolonged strike, women group strike, is it a supervening impossibility? No. Could tender the supplies in March when the winter season was almost over. Whether the company can reject? Yes, you can reject because when time is of essence, the contract is what? Voidable. Whether company can accept the total supply? Yes, they can. They can accept the total supply. When they reject, can they claim the damages? Yes. When they accept, can they claim the damages? Yes, only if they have mentioned it. See, this question, even though it's a direct question, I want to tell you something. Like there was once a question, what are not the disability of a partner unregistered firm? People went and wrote it. They wrote, but they wrote disabilities. So please understand, you have to answer what the question is asking you. Here, explain the additional features. All checks are bills, while all bills are not checks. Explain the additional features of a check which differentiate a check from bill. Now, what people write? They will go and write the differences of check and bill. That is not what the question is asking. They are asking you to tell the additional features. Only that you're supposed to say. So that too, it's always payable on demand and it's always drawn on a specified banker. That is your answer. Ashoka trader delivered a camera to Mangesh on sale or return basis. Mangesh delivered the camera to Rahul on the terms of sale for cash only or return. Okay. Ashok gave it to Mangesh on sale on approval. Mangesh gave it to Rahul on sale for cash only. Sale on approval but on cash basis. Rahul gave it to Vishal. When Mangesh gave it to Rahul, as between Ashok and Mangesh, it is what? It is a sale. When Rahul gave it to Vishal, generally it would have been a sale, but it is on cash basis, so it is not a sale. So who is the owner here? Mangesh. The camera, which was in the possession of Vishal, was lost by theft, though he exercised due care. If he would not have exercised due care, Vishal would be liable. But it's saying he exercised due care. Referring to the provisions, analyze the situation and advise whether Mangesh, Rahul, or Vishal are jointly or severely liable to Ashok for the price. It is only Mangesh who is liable and no one else. Ansari of Jaipur sold 100 smart TV sets at 50,000 per set to Baburam of Delhi. He delivered the TV sets to Chetan, a transport carrier, for transmission to Baburam. Baburam further sold these 100 TV sets to Shyamlal at 60,000 per set. On reaching the goods at the destination, Baburam demanded the delivery, but Chetan refused to deliver the goods to Baburam. That is why he failed to deliver the TV. When the seller wrongfully refuses to deliver the goods to the buyer can claim the damages from the seller. Correct? That is why he failed to deliver the TV sets and suffered a huge loss. Ansari came to know about this. He directed Chetan to stop the delivery to Baburam and re-deliver. Seller can exercise his rights of stoppage only in the case of insolvency of the buyer. Whether Ansari has a right to stop the goods in transit? No. Whether Babu Ram can claim the loss that he has suffered? Yes, but he can claim the loss that he has suffered due to non-delivery, but he cannot claim the loss that he suffered due to not selling the goods to Shyamlal because that is a special damage. Aman drew a bill of exchange on Baban, who accepted it payable to Magan or order. Magan endorsed the bill to Gagan. Gagan endorsed the bill to Akash to be delivered to him next day. However, so he had not delivered it. Endorsement was done, but delivery was not done. And unless delivered, endorsement is not valid. We already know. However, on the death of Gagan on the same day, his only son Ankit delivered the bill to Akash. Is it a valid delivery? Not valid delivery. Why? Because it is only the endorser who should deliver. Any other person can deliver on behalf of the endorser if authorized. Here, there was no authorization. On presenting the bill on the due date, Baban refused to pay. Can he refuse to pay? Yes, he can. Explaining the importance whether Akash can enforce the payment. No, he cannot because the endorsement was not valid. Reliable Limited, an Indian company, is a global leader in petrochemical products. For payment of the sale price of machinery imported from LX Manufacturing Limited, a USA based company, the Indian company drew a bill of exchange on Manish. So it was drawn in India. Bill of exchange on Manish, a resident of Mumbai. It was drawn on a person resident in India who accepted the bill at Mumbai payable to the exporter in Los Angeles. It was payable to a person, it was payable outside India. An inland bill is a bill which is drawn in India. This is there, has to be there, and it can be drawn on a person resident in India or it can be drawn payable in India. Here it is drawn in India and drawn on a person resident in India. So is it an inland bill? Yes, it is an inland bill, right? Okay, with this, we are done with all the practical questions. Happy learning and stay motivated. Thank you so much.